Hey everybody, welcome back to the channel. So, I wish I wasn't doing this video, but I'm going to do it anyway. I'm not even going to roll an intro. I'm just going to cut to the chase because I'm getting a lot of pushback regarding my small claim suit against Uber Technologies, LLC. And I'm getting a lot of stuff saying, you know, their lawyers are going to eat you up in court. I'm stupid. It's a waste of money. Blah, 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 blah. Well, I could tell you exactly what I have in mind and exactly what I'm going to present to the court on the 28th of February this month. But I'm not stupid, because if Uber sees this video, they're going to know what I'm going to present before I present it. I've given them their paperwork. That's all they need to know. And that's all, unfortunately, not to be rude, that's all I can say until after the court hearing. And then I'll let you know exactly what happened, unless I'm bound by a gag order. So, first and foremost, the attorneys. I want you to look. I'm going to show you a couple of screenshots and explain. I'll even read them to you, but I want to explain five different concerns. Okay, so let's just get to it. Here is screenshot number 1. You are not allowed to have a lawyer represent you at the hearing in small claims court, but you can talk to a lawyer before or after the court. In general, an individual cannot ask for more than $10,000 in a claim. Businesses cannot ask for more than $5,000. Let me repeat that for you, just so you're completely clear. I am in California. You are not allowed to have a lawyer represent you at the hearing in small claims court. Okay? If that doesn't get your attention and you still don't believe it, I don't know what to tell you. And that is actually from Santa Barbara Superior Courts. Still California. It's still a California Superior Court. So, no, Uber's attorneys are not going to rip me apart, because Uber's attorneys are not allowed to be there, okay? I hope that answers that. Screenshot number 2. Penal Code 116.510. The hearing and disposition of the small claims action shall be informal, the object being to dispense justice promptly, fairly, and inexpensively. Let me repeat that one. Penal Code 116.510. The hearing and disposition of the small claims action shall be informal, the object being to dispense justice promptly, fairly, and inexpensively. Small claims court. So, inexpensive, yeah. Promptly, yeah, only took just a little over 30 days. And fairly, yes, because there's a judge. Let me show you screenshot number 3. Nothing in this article, I'm sorry, let me back up. Penal Code 116.531. Nothing in this article shall prevent a representative of an insurer or other expert in the matter before the small claims court from rendering assistance to a party in the litigation, except during the conduct of the hearing. Okay, let me repeat that. Penal Code 116.531. Nothing in this article shall prevent a representative of an insurer or other expert in the matter before the small claims court from rendering assistance to a party in the litigation, except during the conduct of the hearing. Again, that means that nobody is allowed in there except for me, the plaintiff, and Uber, the defendant. Okay? either before or after the commencement of the action, unless otherwise prohibited by law, nor shall anything in this article prevent those individuals from testifying to facts of which they have personal knowledge and about which they are competent to testify. All right. So, once again, they really can't even have anyone represent them. And there's a reason why I'm bringing this up. But I want to get to the last screenshot. And, well, you know what? Screenshot number 4. Check it out. Penal Code 116.540. Except as permitted by this section, no individual other than the plaintiff, me, and the defendant, Uber Technologies, or in this case, the person I named, who is Dara Khosrowshahi, may take part in the conduct or defense of a small claims action. Let me repeat that for you. Except as permitted by this section, Penal Code 116.540, no individual other than the plaintiff and the defendant may take part in the conduct or defense of a small claims action. Except as additionally provided in subdivision I, a corporation, Uber, may appear and participate in a small claims action only through a regular employee, Dara Khosrowshahi, or a duly appointed or elected officer, Dara Khosrowshahi, Chief Executive Officer, or Director, Dara Khosrowshahi, who is employed, appointed, or elected for purposes other than solely representing the corporation in small claims court. Meaning, you can't have any legal background. You can't have somebody come in and represent you if their sole purpose is to represent you in court. That means that you don't even have to have legal experience in order for that to happen. All you have to do is say, I'm here to represent them. My job is to represent them in court. Guess what? That's not legal. So, I don't know how else to explain it. The only thing I can tell you is when I filed my small claim suit, I'm sorry, I'm looking at it right now. So, again, it seems, if you see it, maybe it's more believable. I don't know. If the defendant is a corporation, limited liability company, or public entity, list the person or agent authorized for service of process here. I did the smart thing. Dara Khosrowshahi, Chief Executive Officer for Uber Technologies. There you have it. And lastly, part number 5. I'm not an employee. I'm an independent contractor. I was. And as part of getting access to drive on their platform, I enter into their binding arbitration clause. However, I opted out. We have that option. And I'm no longer an employee. As a matter of fact, I never was an employee. Binding arbitration is for employers to basically say, if you want to be an employee of ours, you have to agree to binding arbitration. Because, if something goes wrong, we don't want it to go to court. Oh, God, we want to brush it under the rug. And we're going to arbitrate. Guess what? We're not employees, are we? As far as Lyft and Uber go, and what they state, we are independent contractors. So, as an independent contractor, the arbitration is null and void and is actually non-acceptable. You may have to agree to it when you hire on with one of these companies, but you're not an employee. So it's voided as soon as they put you on a platform, technically. So if we're independent contractors, but we have to go to binding arbitration unless we opt out as an employee, then we're an employee. So these companies are so screwed up. All I want you to do, all I'm trying to do is let you know is I'm not afraid to stand up to get this done. Sorry, the video went on a little bit long. Lastly, if you want somebody to write a letter for you, great. Pay somebody to write a letter for you and send it to Uber to try to get you reactivated if you believe you've been wrongfully deactivated. 95% of the time, they're going to look at that letter, they're going to read it, and they're going to throw it in the garbage. Why? Because they know that after that letter, there's not going to be anything. Well, you know what? I'm going to keep going. I'm going to take it to small claims court. And I'm confident that I'm going to win. If I don't, then I've learned a lesson. But I'm not giving up. I'm not going to just let these guys walk all over me like they walk all over everybody else. And I hope that when this is all over and I win and I get my judgment, that everybody does the same thing. You want to pay somebody to write a letter? Pay somebody to write a letter. But if that doesn't work, stand up for yourself, for your rights, and for what you have earned, and take them to court. Fight. Don't be afraid of the companies. Make the companies afraid of you. Until next time, be safe, be professional, keep it real. If you must, drive on, and I will talk to you later. Wish you all the best of health.